Minister, firstly, I'd like to say that there is no excuse for domestic violence, and that where it is women who are in the main the victims of such abuse, men may also be victims, and we shouldn't forget this. The Act of 2018 has some welcome provisions, such as Section 29, which allows a court to recommend that the perpetrator of domestic violence engages with certain services, such as a programme for perpetrators of domestic violence, with the addiction services, counselling or psychotherapy services, or financial planning. These are essential services, very essential services, the provision of which assist all concerned, but particularly as the victims and their families need to be safe in the knowledge that the perpetrator has engaged with professionals to address their abhorrent behaviour. Minister, my question is, are these services readily and speedily available, and are they provided free to those of limited means? My second question relates to Section 5, subsection 2, paragraph P of the 2018 Act. This section allows the court to take into consideration whether the victim of domestic abuse is economically dependent on the perpetrator. Whilst I understand that Section 15 allows for maintenance applications to be heard together with the Act of 2018, there will be circumstances, because of the necessity for speed in applications of domestic violence, that the application for maintenance under the Family Law Maintenance Spouses and Children's Act 1976 may have been overlooked or may not be before the court at the same time. Where this scenario arises, there should be provision in the Act which allows a court to take the equivalent of make the equivalent of a financial maintenance order without the necessary paperwork, if only on an interim basis. Can the Minister give his thoughts on such a provision being implemented? My last question, Minister, is that whereas ex parte applications for interim orders in domestic violence are heard expeditiously, the hearing of final orders can be as far away as 6 months and longer in some instances. For victims, delays cause great anguish. In fact, great anguish for all parties concerned. Minister, do you accept that such delays are unacceptable? And can the Minister tell the House how he would intend to address the matter? Thank you, Ceann Comhairle.
I want to thank the Deputy for her contribution and acknowledge that notwithstanding the fact that we were in an unprecedented pandemic during the course of the last few months, that I was very pleased as Minister for Justice to liaise on a very regular basis with both the court services, which has a long association with my department, and the Garda Síochána, in order to ensure that the system responded where appropriate and necessary. In fact, for the benefit of the Deputy, let me say in response to her question in relation to the civil proceedings, that from the period of the 16th of March to the 12th of June, for which a number of pandemic-related measures have been implemented, there were applications for 1,761 protection orders, or in fact 1,761 protection orders were granted by the courts. That amounts to 87% of the protection order applications. In respect of barring orders, 312 barring orders were granted, many of which are still very much in evidence. On the matter of safety orders, 188 safety orders were granted and 192 actual barring orders. Sorry, the earlier of 312 was interim barring orders. And can I say in response to the Deputy, I acknowledge the point she makes in relation to interim orders and the need to ensure a prompt and adequate response by the court service in respect of a final order, because oftentimes, particularly in respect of particularly sensitive cases, any delay will add further trauma, upset, worry and anxiety of an unacceptable basis. I don't have any evidence of there being inordinate delays. I was happy to report that in Wexford, in the South East, both the District Court Family Law and the Circuit Court were in operation. Obviously, as the restrictions are now eased, we will see more and more court hearings in order to ensure that justice is delivered in a timely fashion. On the matter of the maintenance payment, again, there were issues at the beginning of the pandemic where there was less than certainty around, for example, access, visitation rights, how they would be implemented, having regard to the travel restrictions. Again, pleased to say that both the Gardaí and the court service, through their information campaign, soon dealt with whatever less than certain narrative was out there, and I don't believe that there was the level of confusion that might otherwise have been the case. In respect of financial orders, I am satisfied that in terms of attachment of earnings, in terms of investigation means tested, that the courts are equipped with an appropriate level of powers to allow for due diligence and to allow for justice, particularly in the matter of maintenance payments in respect of women and children. Obviously, the Family Law Code, in terms of the legislative provisions, remains constantly under review. I have for the past 3 years engaged with the Justice Committee, with deputies here in the House at question time. I'm satisfied that over the past 3 years we have made considerable strides in improving our legislative framework, and that will continue into the next Dáil. If the Deputy has any specific questions or queries, I would be happy to have them examined, and I will further communicate to her in respect of the issues as raised. I do want to acknowledge, however, on the part of the Gardaí, the fact that they remain very active in the course of the emergency, as has been acknowledged by the deputies. Operation Puishev, in particular, in 2 phases. Firstly, the Garda Victim Services offices making on a daily basis proactive contact with victims who have reported domestic abuse in the past in order to update the files, update the calls. I had a number of meetings with Gardaí in order to assess how these undertakings were developed. And of course, there were a number of victims who used the opportunity to request further assistance from not only the Garda Síochána but from local service providers. So I'm happy to ensure the Deputy that we are in receipt of reports and that obviously lessons will continue to be learned for future plans and development.
Minister, just a question in relation to services being readily available, and if they are available free and provided to those free of limited means.
Yes.
Well,
particularly psychological and psychiatric assistance for people with trauma.
I appreciate that, Minister. And it's not just, as we know, provided for the perpetrator, but it is an essential service for the family, the victims and the children of such abusive or domestic violence situations. And in that, I'd like to just put it on the record that many of the organisations, and there are not enough, but there are some, who depend greatly on charity in which to provide these services. And as we know, one of the big travesties of COVID is that none of these organisations have been able to raise funds. And I think that it's going to put pressure on these services. It's going to mean that maybe court orders, whilst it's at the discretion of the judge, may not be the judge may decide not to recommend it based on the pressure that the services are under, and that is certainly something that we don't want to see arise in society. We need to transform the lives of victims so that this behaviour doesn't impact on the whole of their life. Thank you, Minister. Thank you, Councillor.